Good afternoon, everybody, and thank you for joining us and attending this remote seminar. My name is Louise Whittington, and I'm with my colleague Jamie Fireman. We're both members of the housing group here at 42 Bedford Row. Hopefully everybody's been able to join. I'm conscious we've started dead on 5 o'clock. This seminar is going to consider enforcement of settlement agreements in the context of disrepair claims. We will hopefully provide quite a practical overview of and deal with quite a lot of the procedural issues and things that have cropped up in our own cases over the past few months and have been informed by other practitioners and chambers. It's not going to be overly legalistic because there's quite a lot of concepts and practical considerations that we wanted to discuss primarily. We're also going to be focusing on enforcing an agreed terms relating to completion of works or schedules of works, rather than enforcing a damages agreement. That's particularly because it's not unique to disrepair, and the principles in enforcing a settlement agreement in relation to an agreed sum for damages, it would be subject to the normal principles of enforcement. Obviously, there's some quite unique and different issues to consider when looking at enforcing an agreed schedule of works, particularly the timeframes and the type of application you want to consider. We will deal with any questions at the end of the seminar, and I'm now going to hand over to Jamie.
Let's see if I can move this slide on smoothly. Okay, so you might be wondering why we decided to do a seminar on this particular topic and why we think it's relevant. And the answer, in short, is that we have generally in chambers, and I know personally I have, and Louise has, seen a real increase in these sorts of applications or claims being brought to court intending to enforce settlement agreements that have been reached to do works in a disrepair context. The likely reason for this, I think, is really a combination of factors. First of all, one can't deny the impact of the pandemic. It's clearly had an impact on disrepair claims more generally. There's been a huge increase in claims for damages and specific performance of work schedules to be carried out because of the impact of the pandemic, because of the existing disrepair that was in existence before the pandemic getting worse, and also, of course, the impact on accessing properties as a result of the restrictions that were put in place to deal with COVID-19. And of course, one can't ignore that there does seem to be some issues within the public housing sector in terms of actually arranging for disrepair issues to be resolved. And all of these issues, including, in fact, the at least anecdotal accounts that we've had of there being issues with getting contractors in to actually resolve these works and getting their availability, first of all, ensuring that they are available, second of all, ensuring that they can come and do works at a time that suits the claimant or tenant as they are at that particular point. And the difficulties with that, combined with the issues of the pandemic and all of the ongoing issues with the backlogs of all public services, has led to, we think, an increase in a lot of these claims. And also, one can't ignore that these particular claims are not subject to the fixed cost regime in the way that something like personal injury claims are. And so there is another opportunity for claims such as this to be brought and the opportunity to recover costs. So all of these factors have led to there being an underlying issue in terms of there being an increase in disrepair claims as a whole. And that combined then with the issue of actually completing the work being impacted by the pandemic means that actually when you have an agreement to resolve any existing disrepair in property and a deadline has been set, that deadline then obviously needs to be more realistic. And when I say more realistic, I mean it perhaps needs to be more generous than it otherwise would have been. And not taking into account those factors, but acting perhaps in the way that you would have acted before the pandemic and before all of these issues were as extensive as they are now, has led to a lot of those deadlines that are set within an agreement being missed. And then that leads to what we're talking about today, which is trying to enforce an agreement once a deadline for works to be completed has already passed. And so that's why we think it's relevant. That's why we think it's coming up more often. And so we've decided to talk about that in light of this being much more of a common issue nowadays. And so in terms of where we start when looking at trying to enforce an agreement, the obvious point and I do stress it is an obvious point, but also a very, very important point, is what do the terms of the agreement say? What is it that is actually being agreed to? And the first point is what work is required? What work does the landlord have to do as a result of the agreement? And this is really important because it's not the case when seeking to enforce a settlement agreement for a claim brought as a result of disrepair that we look at what the existing disrepair is. We look at what work has been agreed to be done, because what we're seeking to do is enforce the agreement, not relitigate the issue in terms of what disrepair was in existence when the agreement was reached. And I think that's an important distinction. So let's have a look at, first of all, the agreement. And obviously, following the pre-action protocol for housing conditions claims, it's highly likely there may well be a surveyor's report. And the surveyor's report is going to have usually a schedule. And it's usually going to be the schedule of works that will be agreed. But there may well be more than one surveyor's report if a joint expert hasn't been agreed. And that's obviously quite a common situation when you have a defendant and a claimant's expert. Well, in that case, which of the expert schedule or both is agreed? And that needs to be spelled out. It shouldn't just say, and I have seen it in certain agreements where it simply says the schedules of works are agreed. But I think that may well make sense to the people who are drafting the agreement, but it might not make sense to a court. And when coming to enforce that agreement, you may be in difficulty because you haven't been specific enough about exactly what work is agreed, and therefore it's difficult to actually say what hasn't been done. So again, a simple point, but explain exactly whose schedule, if there is a schedule within an expert report, is being agreed. Is it a schedule that's been come up by the parties, been put together by the parties? If so, explain the schedule dated, whatever the date is. And is it the whole of the schedule of works as agreed, or is it only agreed in part? It may be, for example, that the landlord says, well, I accept that items 1 to 15 of the schedule of works in the expert report constitutes disrepair, and that we have a duty to do the repair works in that context, but we don't agree that we have any duty to do the works from 16 to 20, for example. And so we're only agreeing within the context of this settlement to do works from 1 to 15. And so that's very, very important starting point in terms of what the work is. And the second point is, what's the deadline for completing that work? Often you'll see a generalized comment such as a clear number of days, like something like 56 days to do the work. But when do those 56 days start? It's really helpful, if possible, to put in a settlement agreement the number of days and when that number of days starts. Does it start from the date of the agreement? Does it start from a week later? Usually you'd expect it to start from the date of the agreement, but any clarity that can be achieved on that is going to be beneficial when it comes to enforcing. Equally, it'll be very helpful, though I can see why a landlord may be hesitant to do this, to put a final date on the agreement by which works are expected to be completed, because it's then very easy to say to the court, look, that deadline has passed, or the work should have been done by X date and it hasn't, as opposed to then having to calculate when does the 56 days kick in. Of course, we are hopefully all capable of doing that, but any clarity that can be achieved is to be to the advantage of when it comes to actually enforcing the agreement. But most controversially, and likely to be the most specific issue that crops up in these hearings, are what are the provisos that have been put on doing the work? And I say this because generally, quite properly, most landlords will be reluctant to say that they're just going to do the work within 6 weeks or 8 weeks or however many days that have been agreed, because it may be that it's not possible to do the work for a number of different reasons. The most obvious reason, obviously, is getting access to the property, and that requires some compliance by the tenant, granting access to contractors to allow them in to actually complete the work. This is where being specific is really, really important. And because you can, and I have seen some agreements which use generalized terms that are actually quite difficult to interpret. In the slide there, I've used the example of subject to access being quite a generalized term, rather than saying something like subject to the tenant granting access within 48 hours of a written request being made. The reason I draw that distinction is because subject to access can be very generalized. It doesn't necessarily mean that much. It means that subject to getting access to property, but what does that mean? Does that mean whenever the landlord wants? Does it mean asking the landlord for access once, twice, 3 times? It's difficult to interpret on its own. Whereas if you have a specific point, such as once a request for access has been made in writing, it's then very easy to evidence whether or not those requests have been made, And if they have been made, it's much easier for a landlord to say, look, well, I've tried to gain access, I've made these written requests, but no response has been received, and therefore I haven't breached the agreement. It's the tenant who's breached the agreement by not allowing us access, and we shouldn't have any action taken against us for failing to do the work because we couldn't have done the work. There's a similar point actually to be made with these provisos with respect to the pandemic, because a lot of provisos have been put in place, such as subject to COVID-19, but it might be better in my view, sorry, I've just been in court and that's obviously gone into my brain, it might be better in my view to say something like subject to there being no national lockdowns being imposed, or something preventing access like that, rather than just saying subject to COVID-19 in general, because that could mean anything. It could mean something like, I don't know, COVID-19 cases being cured across the globe, which is obviously not going to happen in any time soon, and therefore renders the agreement pretty useless. So again, the overall point really is just be as specific as you possibly can be, and that will allow enforcement of the proceedings to be much clearer.
And on that point, Jamie, I think it's important for both parties, or they're both incentivised to have clear terms, because the defendant or landlord doesn't want to be in a position where they're in essence defending an application or opposing a Part 7 claim, for example, where, and it's something I've seen, where they've said subject to the coronavirus pandemic without making reference to national lockdowns. What that could lead to is quite protracted, or certainly a lengthy hearing, arguing about whether the meaning of those terms and whether they should or haven't applied, or whether they've breached the agreement and whether they should be compelled or forced to complete the works. And actually, I don't think that's in either party's interest. It's better to have clarity when the agreement is drafted, not only to enable quick enforcement, but also for both parties to know what the nature of the agreement is.
Yes, and I think it's also, touching on the point I was trying to make before, it's also important to know, or to consider, what does it actually mean in terms of gaining access? Has access been requested sufficiently by making one request, or should a landlord make several requests? Well, these are all relevant points in terms of the court's consideration of whether or not to make orders and what orders they will make. But it's, in my view, likely that you need to do more than just simply make one request for access. But being as specific as you can allows you to then say, look, these are the steps we've taken. Bear with me 1 second.
Thank you, Jamie. The next concept that we want to deal with is really the legal status of the agreement. And obviously that's going to impact conceptually how we consider enforcement. And something to bear in mind is that where you've entered into a settlement agreement with the other party, that is contractually binding upon you. And particularly if you're the landlord, you would have a legal obligation to complete the works as really set out within the schedule, if there is a schedule, or within the terms of the agreement, and by that specific date. And this is going to impact the way that the parties and the court considers these agreements, and the way that they're particularly looking at claims for either for damages or for when the order should be made. It's going to impact because this is an agreement that's been readily entered into by both parties. We've hoped, obviously, if there's any issues about duress, that's entirely separate. But if there's a failure to complete the works, that would amount to a breach of contract, because it's an agreed term. You wouldn't have a settlement agreement without a specific term on when the works needed to be completed by. And again, something that should be borne in mind is the fact that this is, if a settlement was reached, it's either because a claim was contemplated or a claim was issued. And where you've failed to complete works as you've agreed, you've caused delay in essence, and the court will look on this quite negatively, in my experience, because you've already agreed to complete the works by a certain date. And obviously there may be reasons and a very valid defence on why you've not been able to. But actually the starting point is that you've entered into a legally binding agreement and you failed to do what you promised to do. In terms of the next stage, and when we're looking at the legal status of the agreement, even though it is contractually binding, any enforcement is not going to be automatic, and you are going to have to make an application or issue a new claim depending on the type of agreement, which we'll consider in a moment. And often the order that you're asking for is in essence an order for specific performance to ensure that the work's completed by a specific date. Obviously, in quite extreme cases, you might be considering asking for a penal notice to be attached to that order. For example, if there's multiple occasions of non-compliance, for example, an agreement's been reached where the work to be done by a certain date, that date's not been met and the works haven't been completed, you've then extended the terms and you've got a new date. Again, there's evidence and particularly correspondence which shows you've not met that deadline either. Then the applicant or claimant, which would be the tenant, could consider applying or asking for a penal notice to be attached to that order for works. And obviously in the worst case scenario, if the works are still not done by a certain date, then they could contemplate committal proceedings. There's also the issue of an agreed sum of damages, which would normally form part of any settlement agreement, where you've had ongoing disrepair for a certain amount of time and there's been some compromise of any damages claim. And that is a little bit more straightforward to enforce, but could be done in the same ways that we'll discuss throughout this presentation. Finally, obviously, when you make the application is going to depend on when the works needed to be completed by. And this is what Jamie was considering in the previous slide, namely, what date was it agreed that the works would be done by? And there would be a set time limit. You wouldn't issue an application until that date has passed. Obviously, you can't enforce something which is not yet, in essence, come into effect, or you've not given them the opportunity to comply with the terms of the settlement. A practical point to bear in mind is whether you wish to enter into any further discussions regarding those time limits. For example, the date for when the works order or work schedule needed to be done is passed. You could have further discussions with the other party and say, if you're not willing, or if you fail to complete the works by, in say, a further 14 or 28 days, we will issue an application. The last factor that, just as preliminary issues to bear in mind, is looking at what is the legal nature of the agreement. And that's really what stage in proceedings are we at? Are we pre-issue? Are we post-issue? And then what type of settlement agreement was reached? Do we have a Part 36 offer? Do we have a Tomlin order? And so that leads us on to analysing the nature of the underlying agreement. And it obviously seems like quite a basic point to deal with, but it's surprising how often the wrong type of application is made, which is going to be a waste of the party's time and obviously the court's time and increased costs. We've broken this down into 3 categories. Obviously, the first is pre-issue offer. This would normally be where a letter of claim has been sent in accordance with the pre-action protocol for housing conditions. I would anticipate that a surveyor has been instructed, possibly on a joint basis, or both parties have instructed their own surveyors. And then you've got an agreed terms about that work that needs to be completed by. But obviously you've not issued your claim if the settlement is reached in this type of case. And that's going to impact the type of either claim or application that you need to pursue to enforce the terms of the agreement. The second category that we've considered is a Part 36 offer. And it appears to be that this is, I would say, is probably the most common type of offer and settlement that's reached after a claim's been issued. And that's for fairly obvious reasons. Primarily, there's an incentive for both parties to make realistic and helpful Part 36 because of the cost consequences that could apply, and obviously the benefits if you're successful at trial and you beat your Part 36. Where a Part 36 has been accepted by either party, the disrepair claim would be stayed pursuant to CPR 36.14.1. And that again is going to impact the next step in terms of enforcement. The third category is consent or Tomlin orders. And so this could be a settlement which takes place post-issue without the substantive hearing taking place, so without the court adjudicating upon the liability and quantum of the disrepair claim. And the terms of the agreement are set out perhaps within the schedule, which would be a Tomlin order. But it is possible that the parties could write to the court with a consent order asking for the proceedings to be stayed, and the actual terms of the settlement agreement appear in a letter, for example. So there are different types and different forms that would take. But I would say it's probably more common to see a Part 36 if the claim has been issued because of the cost consequences. I don't know whether you'd agree on that point.
I agree with that. But I have also seen a lot of, and I'm about to just start talking about it, agreements that are some standard agreements that are reached, if I can put it like that, standard non-party Part 36 agreements made pre-issue. And I should just say, I have seen a couple of people put their hand up, but we'll get around to responding to questions at the end. If you have any questions, presuming that's why you put your hand up. But in terms of dealing with that first point, non-Part 36 pre-issue agreements. So as Louise said, of course, the pre-action protocol for housing conditions claims clearly anticipates there being a settlement, and that's entirely right, because these sorts of claims are ripe for settlement. And so in the circumstances we have something like just a standard memorandum of agreement or just a standard email exchange that's led to an offer being agreed, I'm looking at what you do in those circumstances. What's the correct way of enforcing that sort of agreement? Because there are actually various options, and I've seen people do different things. So just to be very, very straightforward about it, one option is to issue a Part 7 claim, first of all. And the reason you need to issue a Part 7 claim is because in the event where the settlement is reached pre-issue, of course, there is no underlying claim. There's nothing to piggyback off, but there are no proceedings in court. So you need to issue fresh proceedings in order to enforce the settlement agreement. Of course, the works that need to be done, a claim could be brought alongside a claim for or an application for a mandatory injunction or a claim for specific performance, both of which are in effect different ways of achieving the same thing. Really, they're pretty much the same thing in practice, but ultimately procedurally could be a bit different, in that if you're applying for a mandatory injunction, you may wish to make a Part 7 claim, perhaps for damages or breach of contract, and separately issue an application for a mandatory injunction for the outstanding works to be completed. And that's why I've also dealt with breach of contract claims separately, albeit the reality is you probably would do something like issue for a breach of contract claim through making a Part 7 claim, and then claiming the alternative for specific performance or a mandatory injunction to be ordered. Or you may also wish to make an application for an interim payment of damages under CPR 25.11K if you want to make a claim for the damages to be ordered more expediently. However, an important point is that I'm not suggesting here that you make an application for an interim injunction. I suggest that perhaps a combination of the above would be worthwhile, but not an application for an interim injunction. And that is something which I'll deal with now. And the reason for that is that if you are making an interim injunction application, of course, there are some advantages to that. Now,
I was about to say, I think it's quite commonly issued. Certainly quite a few people in chambers, we've encountered this quite a lot recently, because parties know that you'll get an expedited hearing date if you make an application for an interim injunction, rather than just, you obviously can issue a Part 7 claim with an application for injunction, but not asking for an interim hearing, in essence.
Yes, and that's probably because of two things. First of all, if you do make an interim injunction, you'll first of all have to satisfy the American cyanamide test, which would be, is there a serious issue to be tried, then looking at whether damage would be an adequate remedy, and the balance of convenience and where that lies. And it's likely that you're probably not going to be able to justify the urgency where a deadline has only just been missed, or in fact justify that damages couldn't adequately compensate someone in circumstances, depending, of course, on how extreme the disrepair is. I do think it may well be possible to consider a circumstance where an interim injunction was appropriate, but it's not likely to be the case that it is. And that brings us really to the comments in a now very old case, Parkman and Camden, where it was said that really only in the most exceptional circumstances would a disrepair or cases relating to disrepair give rise to actual and immediate major discomfort and inconvenience, and to a real risk of damage to health flowing from the admitted breach, and in essence justify the granting of a mandatory injunction on an interim basis. So whilst it may be appropriate to apply for a mandatory injunction finally and make that application alongside your claim, you're unlikely necessarily to succeed on the interim basis. And what that means is, whilst you have the benefit making an application for an interim injunction of getting a quicker hearing date, you run the risk, certainly, of having the application for the interim injunction, if that is part of the claim or the only part of the claim, but let's imagine it's just one of the two elements of the claim, that particular element of it could be dismissed, and you've just wasted time and costs applying for something that you're unlikely to get, when actually the underlying enforcement application or enforcement proceedings are actually very good and have good prospects. Potentially for defendants, they will want to think about, well, actually, this we can defend this on the basis this should be a mandatory injunction application, if at all, and we can get the interim injunction application dismissed. So, in our view, very clearly, the right thing to do most likely would be to make a claim, for breach of contract and seek damages as a result of the breach of contract, as well as accompany with that an application for a mandatory injunction or a claim for specific performance. So what are the valid defences to this sort of action? Well, the obvious point is, of course, that the agreement itself hasn't been breached. And we're going back now to my original point about what are the provisos. And this is something which is often relied on, and rightly so, and especially in the context of missing a deadline, because there may well be issues with access. The important thing here is, what does the proviso say? Does it say subject to access generally? Well, then you're going to have a long argument about whether or not you have achieved, you have been given the opportunity, if you're the defendant, to actually access the property, and that's going to then take up a lot of time. But it may well amount to a valid defence if you can establish that you've made reasonable attempts to access the property and those have been prevented. Equally, if there has been an event, for example, as we talked about before, a lockdown being imposed, that may well justify saying, well, this agreement hasn't actually been breached at all, because the deadline hasn't kicked in. Or in fact, where the tenant has been obstructive in preventing access, it may be possible to argue that actually it's the tenant who's breached the application, who's breached the agreement, and therefore it's the tenant who is at fault and is in reality in breach of contract. And so no enforcement action should be taken against you as the landlord. Or alternatively, if you're acting for the tenant, you could say, well, there may well have been one application, or one attempt, I should say, at getting access, but that wasn't enough. And there clearly hasn't been compliance with the deadline that was set. But one really important point that I've seen crop up, and arguments seeming to be wasted, well, court time seeming to be wasted arguing about this particular thing, is looking at whether or not what's been agreed actually amounts to disrepair. It is really important to say that is not the focus of the court. The court is focused on the agreement, what has been agreed, whether or not the underlying agreement constitutes what would amount to disrepair for the purposes of any express contractual agreements or any Section 11 implied duties under the Landlord and Tenant Act, is in many ways neither here nor there, because these proceedings, generally speaking, and what we're focusing on, are not about what is the underlying disrepair, but on what disrepair has been agreed, or what work has been agreed. I shouldn't call it disrepair, it may get a bit confusing, but what work has been agreed by the parties to be done. That's the focus.
And exactly, it's the terms of the settlement that the parties have readily entered into, because the court isn't necessarily concerned whether all of the items in the schedule would have been, there would be liability to the landlord to complete those repairs, because if they're agreed as part of that settlement agreement, you can apply to enforce. And that's it.
Yeah, so that's really the overriding argument about the agreement itself. Is it the case that the specific work that was set out within the agreement has been done, or hasn't it been done? Not what that agreement actually looks like. Sorry, not what that work actually looks like in practice. It's about what was agreed. And so that's really going to be the substance of the argument about the underlying agreement. Then the other defence that's obvious, and we just touched upon, is the circumstances where it may be inappropriate to grant an interim injunction. Or in fact, it may be not appropriate to grant an injunction at all at the date of the final hearing, because it may be that actually there has been a significant change in circumstances. I have been referencing the pandemic a lot, but it has been one of the things that's dominated litigation and the context in which litigation has been done for the past 2 years. And so whilst we appear to be in a different stage of life now, it's not beyond the realms of possibility that we see circumstances that change in such a way that actually, whilst it may have been the case that it was appropriate to bring an application or bring a claim for an injunction at the time, circumstances have changed to such an extent that actually it's simply not plausible to foresee what date it would be appropriate to do the work. And so despite the agreement being breached, you may be able to justify as a landlord defending the application on the basis that it's no longer appropriate to grant an injunction, because it's not clear when access is going to be possible to go and actually do the work. So I'll move on. Now, one other thing to say, and touched on before, is very briefly, of course, it's possible to use this as an opportunity to settle again. That could be settling in the form of agreeing a fresh date for doing the work that was initially agreed to, but it can also be an opportunity for further damages to be paid to the tenant. But it's really important that any damages that are paid, and this is the case if you're settling or if you're bringing a claim, that additional payment of damages is intended to reflect the ongoing suffering and inconvenience from the point at which the work should have been completed but wasn't completed until the date at which it will go on to be completed by virtue of the new agreement. And so it's not a case of saying in general terms that you're necessarily bringing a fresh claim for Section 11 breaches. However, you might be able to agree in a settlement agreement, because you're settling, but actually you're going to agree damages both for new disrepair that's arisen since the settlement was reached, and indeed the failure to actually complete the work in relation to this particular issue or issues by the deadline that was initially agreed.
So that's one benefit of actually entering into those agreements, I think, particularly for the landlord more so than for the tenant, because the scope of the agreement can include not just what would have been considered as damages for the breach, but also for any disrepair up until a certain date. So that could include and contemplate other disrepair that may have arisen since the settlement agreement was considered and agreed.
And I think perhaps it's worth just emphasising that what you would be getting damages for, and I appreciate I hopefully made this clear before, is not disrepair that was originally in existence, because that has been compromised, although it would be possible to deal with that from the date at which the work should have been done.
Yeah.
But new disrepair, not compromised before, potentially you could reach a separate agreement on that point.
We're now going to move on to enforcement of Part 36 offers. And I would consider that this is slightly more straightforward than obviously having to issue a new Part 7 claim where proceedings have not yet commenced if you've got a pre-issue offer, in essence, the topic that Jamie was just talking about. A standard M244 application form can be used because you're obviously in existing proceedings. What's very clear in the rules of CPR 36, particularly at 14.8, is that you don't need to issue a new claim. The Part 36 simply stays the original disrepair claim, and you can make an application to essentially bring it back before the court. And even where you're anticipating obviously making a new claim for damages, you can still include that. So what Jamie was saying about the damages for the loss incurred after the date when the repairs needed to be, or the schedule of works, we call them, the schedule of works needed to be completed by, and the date in which they are going to be completed by. And again, that claim can form part of the application rather than having to issue a new Part 7 claim for those damages. And that again, there is a dispute between the parties, or sometimes crops up in court, and I've certainly seen it in a couple of cases, where is it necessary to lift the stay on the proceedings? You are able to enforce terms that have been agreed within CPR 36 14.5a. So technically you can enforce the terms of the settlement, including asking for an order for specific performance if that was agreed as part of the Part 36 offer. However, certainly in my view, the court requires jurisdiction to determine the new claim for damages. And that's where it becomes a little bit more thorny about whether you should leave the stay in place and simply the court consider enforcement action as separate with the stay on the primary claim essentially remaining in place, or whether you actually got to lift the stay. And I think the way around this is to lift the stay for a limited purpose and to make that very clear in the terms of the order, namely that the stay is only lifted for the purposes of assessing damage occasioned by the breach of the Part 36. And the reason why you want to be a little bit careful about this is because, particularly if you're a defendant or a landlord, you don't want to lift the stay on the original disrepair claim and that claim then proceed. And obviously it shouldn't where you're seeking to enforce the terms of the Part 36 offer, particularly if you lift the stay and then directions are made for directions questionnaires or list another directions hearing. And so I certainly think that it's the best way to do it is for the order to specify very clearly that you're lifting the stay for a specific purpose, namely assessing damages, which leads us on to the last point in respect of Part 36. And that's whether a separate disposal hearing should be listed, whether you consider that as part of the application hearing. And I would say that it's going to be slightly dependent on timing and whether at the time that the application is made, you're asking for there to be a disposal hearing listed on a second occasion or at a subsequent hearing, whether you're asking for the court to adjudicate upon the damages claim as part of that hearing. I think timing and how long the court lists the hearing for will impact that, but also whether at the time you make the application, you've provided a witness statement from the tenant, which sets out the ongoing loss and assists the court in adjudicating upon that. And if you do, obviously there's benefits both ways. But I think the benefit of having a second hearing, particularly for a claimant in these circumstances, is that you then have a further period of court involvement to ensure that the works, if an order for works is made at the application hearing, that then by the time you get to the disposal hearing, it has in fact been completed, because there could be a second breach. And in those circumstances, you might want to be considering asking for a penal notice to be attached to any second order of the court enforcing the terms of the settlement.
I think that's a very interesting point. And I think coupling that point with your point, Louise, about does the court have jurisdiction to determine a new claim of damages, I think it puts in context really a challenge to the traditional view that you should always make a Part 36 offer and always reach an agreement on those terms. I think it makes perfect sense why a Part 36 offer is going to be the preference for most people, given the cost consequences and the natural incentive that then leads to settlement. But it does make it perhaps a little bit more, as you say, thorny in terms of enforcing that and also potentially a new claim, and then may prolong in some ways the ultimate resolution of the proceedings by having to have a separate hearing, although you may think that's a benefit depending on how you view things. Whether you consider actually having court involvement may focus people's minds and ensure actually the work gets done, or whether you actually consider the cost to be a nuisance.
No, exactly. And the final category or type of settlement agreement we're considering is obviously these post-issue agreements and Tomlin orders. And so the format of that, whether that's consent or an Tomlin order, it will not really impact the way that you make the application, because obviously proceedings already exist. You've issued your primary claim for disrepair, and so you don't have to issue a new Part 7 claim. And again, they're going to be quite similar in content to really the end of Part 36. And you can have the same factors that you'd be looking at in terms of non-compliance. The only difference, and I think it's unlikely, but if, for example, you had an agreement that was after issue, and for whatever reason, I'm not sure why you would do this, but for example, if you discontinued the proceedings or they were dismissed by consent, then in those circumstances, you would need to bring a new Part 7 claim. But it would be, the way that you would frame that Part 7 claim would be for a breach of contract rather than for a disrepair. You don't want to bring a new disrepair claim. You would be pointing to, this was the agreement that we reached in these proceedings. I would have thought that most people would stay those proceedings on settlement or on whether that's a post-issue, well, if you've got a post-issue agreement or a Tomlin order, certainly a Tomlin order, the standard terms would be that it stayed, save for the purposes of bringing the schedule into effect or enforcing the terms of the Tomlin order. So I think that covers those issues. Something that I do want to touch upon in terms of the actual order that you're asking for, which I've not set out necessarily in the slide, but is actually if you're asking the court to make an order for specific performance, or that the works set out within the schedule by X surveyor dated X is done, what timings are you going to be looking, or what timings are we asking the court to consider? And I think this is going to vary quite a lot on really a case-to-case basis, because you're going to have competing factors. On the one hand, the court is going to want to make sure that the landlord, or it is possible for the landlord to comply with an order of the court. So they're going to want to hear submissions on that issue about practically when can you complete the work by. On the other hand, and certainly I think that the court will have some sympathy for tenants where they have entered into negotiations and they have settled their claim, or if it's not yet been issued, but they've settled the terms, and their expectation is that the works will be done by a certain date. And that will impact the way that the court looks at this, because ultimately they're not going to give a landlord endless time to complete these repairs, but it's going to be balanced against practically when can the landlord complete the work by. And I think there's quite competing arguments to be raised there. And I do think it will depend on the judge and depend on actually what timeframes were contemplated in the original agreement. For example, if you've got a settlement agreement that provides that all works need to be completed within 6 weeks, I think that the court might then grant possibly a longer period of time if you've made an application to enforce and you're asking for an order of the court that works need to be done by a certain date. Whereas on the other hand, if you've got an agreement which already offers or provides the landlord with a quite generous period of time, I think that the court might say, irrelevant of your capacity of your contractors, you have to prioritise this case. And that's hopefully a point that we've emphasised during this seminar, that this is a very different set of circumstances than simply a disrepair claim. This is where you've entered into an agreement and you've agreed to do something by a certain date. And that will definitely impact the way that the court looks at this. Because if you've made an offer that you will do works by a particular date and you fail to do so, they will be a little bit unsympathetic to arguments saying, well, it's an issue with contractors and entirely beyond our control, because then you shouldn't have entered into that agreement. And I think that will definitely impact the damages. I
was going to say, actually, I think this is a really important point in terms of the interaction between the claim for damages and the claim for specific performance or an injunction. And that's because whilst I think what you say is very persuasive in terms of there having already been an agreement to do works by a set date, and thus the court being a bit less sympathetic in terms of ongoing delay, the courts don't want to clog up time with more and more applications and hearings relating to the same issue. And so they won't want to set the landlord up to fail. Mm. If there is good evidence to actually show that it's going to take 6 months to get this work finally completed, but actually the tenant can be compensated adequately with significant damages to remedy the breach of contract and actually the ongoing suffering they are experiencing, the court may opt for making a higher award of damages, but allowing a longer amount of time for the work to be done, because it is in everyone's interest to avoid further litigation. And what the court won't want is to have a situation where this is then repeated and enforcement action of the enforcement action is taken, albeit it may take a different form, because you would at that point hopefully be enforcing a court order as opposed to a settlement agreement. So what evidence do you need? This is really evidence to support both the claimant and the defendant's case, presuming, of course, the claimant being the tenant, the defendant being the landlord. What is definitely going to be needed is a witness statement of some sort setting out what has happened. Ideally, it's going to be a factual witness with knowledge of the state of premises as they are at the current date of the claim form, or as at the date of the witness statement, post-dating, of course, the claim form. So it may well be the tenant themselves setting out what they've done in their own words, the attempts they've made to get works done, the fact they've been willingly encouraging the landlord to come and do the work, and yet nothing's been done. The fact that things are still not resolved, it may well be, and this is a point we haven't actually touched upon, that work has been done, but it's been done to a standard that actually means the underlying issue hasn't been resolved. And then you have a dispute about whether or not the agreement has been complied with, in the sense that the work has been attempted to be done, but it hasn't actually resolved the underlying issue. And so there it's going to be really crucial to work out, well, what exactly was required by the schedule in terms of the work. Ultimately, the work probably is going to require resolving the underlying issue. That's likely to be the case. The way these schedules are set out in a surveyor's report, it's going to have the underlying issue, for example, damp, and then the work that's required to remedy the damp. It could be that someone comes over and does something, but the damp remains. And then, in my view, the tenant is going to be in a reasonable position to say, look, you haven't actually complied with this agreement. On the other hand, it may be that the court is reluctant to actually grant injunctions or things like that, because you haven't, it's not the case that you haven't done anything as a landlord. You've attempted to do something which has been a greater issue than you first anticipated. So factual evidence about exactly what has been done and what remains to be done and what the state of the premises is going to be really important. Equally, it may be, although I suspect this may be something that doesn't actually come into place till later on in the proceedings, that you may need to get an addendum report from one of the expert surveyors, because they can comment actually objectively on those 2 points about, well, this was the situation pre the agreement, this is the situation currently. I don't accept, or I do accept, that the contractors have done a good job or have made a reasonable attempt to remedy this, or they can say this is unforeseen and therefore cannot be considered to be part of the agreement.
And I think that's where you have to be careful about looking at what was originally agreed. And if there, for example, have been new issues cropped up that weren't and did not form part of the schedule of works, you're not going to be looking, and you can't enforce those in these applications or claims that we're discussing today. And that's being very careful that, for example, if there's a new issue that was underlying but wasn't considered and didn't form part of the agreement, that disrepair is going to be separate disrepair, which you may need to issue a new claim for.
Yes, or as we said, reach a separate agreement.
Yeah.
And then, obviously, I know we've really gone on about this, but you do need to have the underlying agreement. That is the central point. That needs to be put in, of course, appended to a witness statement if necessary. And then also I would recommend putting in any relevant correspondence so that the court is completely clear as to what attempts have been made by the parties to resolve this, what attempts have been made by the claimant solicitors to seek resolution prior to issuing. Perhaps that may well become relevant, but really what attempts have been made to try and actually enable access, or what attempts have been made by the landlord to gain access. And of course, like any disrepair claim, if it's said that this is an issue, or there are a number of issues that are ongoing, photographs are useful in giving the court a flavour of things. There may well be other points that are relevant, other pieces of evidence that are specific to the individual claim, but these sorts of things, these 4 points, seem to be the sort of thing which is going to be universal across all of the claims. So then I'm going to move on now to looking at damages, and are they payable? Well, in many ways we touched on this point already, and so I don't want to spend too long on it, because I think that hopefully you've all got the point that we're making, which is that yes, you can claim the damages, but you need to be specific about when those damages start from. They would need to start from, if the damages are for breach of contract, the point by which the contract should have been fulfilled. So that will be the date by which the work should have been done, and the ongoing distress and inconvenience which flows from that breach of contract. It's not going to be a separate claim unless you bring a separate claim for different points for a breach of statutory duty under Section 11 of the Landlord Tenant Act 1985. It's going to be a claim for breach of contract, and that is where the damages are payable. Taking into account the considerations we were talking about before about the reasons why the work hasn't been done, that will factor into whether or not it's appropriate to award damages. For example, is it the case that actually, yes, we need to have an order for a mandatory injunction at a final stage to get this work done, because that is appropriate in the circumstances, because otherwise it's going to drag on, and there's good evidence to suggest that this is urgent work that needs to be done. However, it may be the case that the tenant has contributed to delays, which you might, in certain circumstances, be able to argue isn't a breach of contract, but that depends on the term. It may not be a term in the agreement that there's any proviso in place about access, and so it may be something that features into whether or what amount of damages is going to be appropriate to award. And that's why we were thinking about what sort of considerations in terms of the level of damages and whether they'll be awarded are going to be thought of by the court. Some of these things are, how long exactly is the delay? Is this a case where actually the tenant has issued the day after the deadline, hasn't made any attempt to speak to the landlord and say, why haven't you done the work? They've just gone straight away and issued another claim to try and seek their costs of litigation. And actually, in fact, the work was going to be done a couple of weeks later and is still set to be done a couple of weeks later. But they've issued, the tenant's issued for an interim injunction urgently. Well, maybe not. I don't think the court will look particularly favourably upon that. It may be that only a few weeks has passed, but several attempts have been made to correspond with the landlord, and it's entirely appropriate to issue in those circumstances. But that's going to be relevant. Also, what is the reason why the work wasn't done? I was speaking about that before. And how much of the work has been done? Is it the case that actually, going back to our schedule, items 1 to 14 have been done, but 15, which is just a little bit of replacement of one particular drawer or something that was maybe or maybe not considered disrepair, but was encompassed within the agreement, hasn't been done. But everything else has been done, well, then maybe we don't think, or the court doesn't think that it's appropriate to award damages. And then, of course, looking at whether or not the injunction-specific performance element of the application or claim has been dealt with. It might be that the court deals with these things separately, and it might be thought that actually you get an injunction and therefore you get damages. But for all of these other reasons, it might be the case that it's appropriate to order the injunction to ensure the work gets done. But looking backwards, actually, the ongoing suffering is limited. Maybe the fact that the tenant has moved out of the property to allow the work to be done, in which case they won't be suffering any ongoing inconvenience, but it is still appropriate for an injunction to be ordered. And then, of course, looking at sort of the more punitive aspect of the court's view, they make it look more unfavourably, and it may be something which sounds in increased damages. Of course, different judges will take different views in terms of whether or not, in fact, this is a proposal made by the landlord, and the landlord said to the tenant that we can get this done in 56 days, but then there's sat in their hands and not done anything. And that really goes back to the point that Louise was making earlier. So all of those considerations, I think, will be relevant when the court comes to consider whether or not to award damages.
And finally, and very briefly, you'll be pleased to hear, just want to deal quickly with costs. And I think very basic principles of cost would apply to whether you bring in an application or whether you're issuing a new claim. And generally, obviously, if you're successful in your application or your claim, you'll be entitled to your costs. I think particularly in these type of agreements where a landlord's failed to complete works by a particular date, the court is much more likely to order the cost of the application because in essence the tenant's been forced to make an application for specific performance to ensure that the work is done in accordance with the agreement. Obviously, conduct will always play a part in costs and the way that the court considers this, and also whether it's broken down into cost of an application or cost of a subsequent disposal hearing. My view certainly is that if you make an application, for example, if you've got a Part 36 offer that you're seeking to enforce, you should get your costs back once you've got your application, so you've got your order that the works need to be completed by X date. But then you'd also get your costs of a subsequent disposal hearing, because obviously the breach of or the failure of the other party to comply with the terms of the agreement has led to damages. And if you recover some damages, you're then entitled to your costs. As Jamie discussed when we were looking at interim injunctions, it's possible that you won't be entitled to your costs if you've made an application for an interim injunction, which is then not granted for whatever reason. It doesn't mean that ultimately your enforcement application won't succeed if you're asking for a mandatory injunction, but not on an interim basis. But it might be that that cost of that particular hearing, which has been listed, may not be awarded.
In fact, it might be awarded to the other party.
Exactly. You might then be having to pay the defendant's costs in attending that hearing. But these are all general considerations that you'll need to factor in when you're making an application or a claim.
Louise, you were just talking about costs, and as we said, I think that the point about whether or not costs will be awarded really goes back to what the basis for bringing the claim has been, and that will then inform in terms of the type of application that's been made. That will then inform whether or not the court does award costs. So I'll give it a minute to see whether or not anyone who had their hand up does type something. Oh yes, go on, Mark. Do you have a question?
Hi, just briefly. I mean, you touched on, well, you talked in a bit of detail about Part 36 offers, but it looked like you were talking specifically about on issued cases. I mean, is it exactly the same if it's pre-issue in a Part 36 offer? In terms of,
if you had a pre-issue Part 36, there wouldn't be any proceedings in existence, and so the court wouldn't be able to deal with your enforcement application without you issuing a new claim. So it would be much more similar to the way that you would deal with a pre-issue. So issuing a Part 7, either with or without an application for an injunction, which just takes a different form.
Yeah.
Hopefully that helps.
Yeah, no, that clears that up.
Yes, sorry, we probably should have made that clear. What we're talking about there is, and the reason we focused more on non-Part 36 pre-issue agreements is because generally they would take the same form, whereas post-issue Part 36 is obviously have their own discrete procedure by virtue of 3614.
I think there was Diane.
Sorry, go on, Diane. Hi, Diane.
Hi there. I had actually had one of these in court last week for London Borough of Hackney, and we had somebody brought a claim against us for, I'm not sure they even put breach of contract on there. I think they did it as maybe an interim injunction for specific performance. It was a pre-issue claim, and they also wanted damages, and we basically put in a defence. They had about 8 items of works. We had 8 items of work we were meant to do. I think they had about 2 outstanding. And the judge actually wasn't very impressed with their application at all, and basically made no order as to costs, and put it down as a small claim. As sort of listed it and said, well, they didn't give a copy of the order at the time, but they said they weren't very happy with them having done it, because it was actually.
Well, that's exactly. Well, sorry, Dan. That's exactly the reason why, when we were discussing what type of seminar we wanted to do, it seems to be that people are issuing either the wrong application or the wrong type of claim. And I've certainly seen, I think people are making applications under Part 25 for interim injunctions, which would, unless there were those specifically exceptional circumstances to justify making an interim order, it's unlikely that the court is going to want to deal with it that way, as you say. And I think that the court, again, they might be a little bit unimpressed if you're issuing for an interim injunction when there's only a couple of pieces of outstanding work. But again, it's going to depend on the context and what's required. But it sounds like in that case, the judge, obviously, if they've reallocated it to the small claims track, the claimant's going to be very limited in the cost that they can recover at any subsequent hearing for damages. Because, and again, something to bear in mind with issuing a Part 7 claim, where you've got a pre-issue offer, is actually the damages that you might be awarded could be quite limited, because it might be for a very limited period of time. And obviously the way that it would normally be assessed is a percentage of the rental value, a diminution in value in essence. And actually it could be allocated to the small claims track on that basis, because the damages claim is quite limited.
So we've got a question here which says, many tenant solicitors issue Part 8 proceedings. Part 8, I think the point is here, for breach, and state the matter should be allocated to the multi-track. So I suppose the point here is really, are they suitable for Part 8 proceedings? I mean, my view is that will really depend on the position of the parties. It is unlikely to be suitable for the multi-track unless the value is so significant that it would put it into the multi-track, in my view. It's more likely to be a fast-track case. But if this is genuinely a case where the landlord has said, look, I admit that this work hasn't been done and that I've breached the agreement, it might be appropriate for there to be part 8 proceedings, but that would really only be appropriate where there genuinely is no or very little dispute, and the dispute is really just about the level of damages, because that's really what part 8 is for. This is a more straightforward approach, obviously. My view is it's not impossible for it to be appropriate, but where there is more likely to be and I wouldn't even go as far as that, it could be appropriate, but generally where there's more of a dispute, I would expect, or at least something to be disputed, I expect part 7 to be more appropriate.
And I also query, if you're issuing, apologies, part 8 claim, that would only be where there's no existing claim. And obviously there's going to be lots of claims which are settled post-issue. And so I certainly think it'd be quite odd if you issued a new part 8 claim to enforce if you had existing proceedings which were stayed, either under the terms of a Tomlin order or a part 36 offer. I think we're now just being sent the questions by email as well.
Yes. So one of the questions we've got is, if someone breaches a tenancy agreement, then you can go for specific performance. If someone makes a bare promise to do repairs after you threaten them pre-issue, why is that a contract that is enforceable if there is no consideration?
When you say bare promise, obviously what we're talking about in terms of pre-issue settlement agreements is they are formal and written settlement agreements. They're not simply a promise to do works. That would be different, and it's not really being contemplated by us in this seminar, because we're generally looking at is where, particularly under the pre-action protocol, you've issued a letter, somebody's issued a letter of claim, you've responded, you might have had a surveyor's report, and then a written settlement terms are agreed with different aspects, normally an agreement to pay damages, an agreement to do works as set out in the schedule by X date, and an agreement to pay costs. And that's what we're considering here. I think if there's just a promise to do works.
Yes, well, a promise being what, just simply an email saying we'll do works by X day. I think what we're talking about really is a situation where actually, if you are to go into the nitty gritty about what consideration is being given, there's clearly consideration on the part of the tenant by not issuing.
Yeah, they've compromised. That's why we've been referencing the word compromise, because it's the claim or the contemplated claim that's been compromised. We've got some questions at the top. Fabian.
Hi there. Yeah, so that was my question. So what I wrote is, a firm in Manchester regularly issues part 8 claims against us, because a lot of times we settle our disrepair claims. 99% of times we're liable, so we just send a part 36 offer, settle it, say we'll do the works within 3 months, offer compensation and reasonable costs. But there's this one firm who sometimes after 3 months we still haven't completed the works. So what they'll do is issue a part 8 claim in court, and that's the first we'll hear of it. They won't send us any lettable for action or email saying, oh, you've not done the works. And so I was just checking to see, is there any obligation on them to send us a lettable for action, or can they just go straight to court?
I would want to double check this point in terms of whether there's anything particularly within the pre-action protocol.
I don't think there was anything in there. But,
I don't think so, where you're essentially issuing after a claim has been compromised and a settlement agreement's been reached. All I would say is certainly go to conduct and costs, as we've indicated when we've been discussing these issues. Particularly if, for example, you complete the works within a relatively short period of time thereafter, possibly before their part 8 claim is even dealt with by the court. And then it may be that their application or their part 8 claim is simply dismissed and they don't get any of their costs back. That's just something to bear in mind.
I think the short answer is, based on our current understanding, albeit we would have to just make sure that this is correct. I don't think there's anything on it. I think the answer is, while strictly speaking, they're not obliged to send a letter of claim. You could certainly make a strong case to say, well, it was unreasonable of them not to. And that, as Louise says, goes to whether or not it's appropriate to grant the injunction, first of all, if they sought one, and second of all, any costs that may or may not be awarded, or any damages as well.
And actually, somebody's asked, we'll be able to access the recording to review. And my understanding is actually it is made available on YouTube for you to view at your leisure at a later date. So if anybody wants to go back and listen to it again, I'm not sure
We've got an interesting question here, actually,
Yeah.
which is, I think, it says in light of FRC, I think that's fixed recoverable costs, being extended to incorporate disrepair claims. How would issuing application / cost recovery for Part 7 claims / disposal hearings be affected? I am understanding that question to be something like, effectively, what would the cost regime be for enforcement proceedings?
Yes, and I think that's what we were touching upon about where the damages claim is going to be quite limited, certainly less than £1,000. If you've only just passed the deadline for when the works need to be completed by, so even if you had quite a high percentage of your rental value being awarded, even say 20%, you're still not, if you're only going to get damages for a relatively short period of time, maybe 2 months or 3 months, you might not get over the £1,000 threshold. But in terms of enforcement, I think it's possible that you would be allocated to the fast track if the outstanding works, obviously amounts, particularly the schedule of works, is of a higher value.
Well, I think that there are 2 things here. I think you've touched on, and actually this ties into another question which was asked about costs, which says that costs of repair works are only under £1,000, then you'd be stuck with fixed costs. I think what's being referred to there is the small claims fixed costs.
Small claims.
So there are 2 issues really. One is, what track does it get allocated to? It would be, if it's going to be allocated to the small claims track because of the value of the claim, you're going to be stuck with small claims costs anyway. Then the question is, does the fixed cost regime that may well be imposed in relation to fast track cases bite when it comes to enforcement proceedings? And the answer is, I don't think we strictly know the answer, because I don't think it's something which has actually been set out. But the likelihood it is possible that this may well be a gap, and actually you may be able to get standard costs. But until this sort of thing is actually set out in any sort of civil procedure rules, we can't say. I would expect that at the moment you probably wouldn't be subject to the fixed cost for the enforcement proceedings.
I would agree actually on that, because you're not. And what we've hopefully stressed a little bit during the seminar is that you're breaching the terms of the settlement agreement. So your primary claim is breach of contract, although it's very rarely actually framed in those terms. And actually, often I see application for injunctions or a Part 7 claim for essentially the damages. It's often not coined or phrased as a breach of contract, but that's actually what you're being compensated for. And you're asking for an order for either a mandatory injunction or specific performance to enforce the terms of the settlement. It's not under the jurisdiction in disrepair itself.
Yes, and just moving on, I think we're probably going to take 2 or maybe 3 more questions, then we'll finish. The reason I'm going to take this one is it's actually quite a straightforward answer. It says, in terms of damages, whether it is for a breach of statutory duty or for a breach of contract, are we still looking at diminution in value in rent for assessing this? And we can say, yes, we are.
Yes, I think that's going to be the only way the court can assess it. So if you're looking at the period after the work should have been done, before the works are the date set by the court, or potentially longer, it's going to still be distress and inconvenience caused to the tenant for that period of time. So.
Yes, and then 2 more questions. This one: what timescales do you find a court will set for completing works when a decan is required? Does this can take several months to arrange? Short answer is we can't give any figures. It's going to depend on the circumstances.
It's very fact specific, and I think that's where actually local authorities or housing associations or landlords providing a witness statement is actually very helpful, so that the court has a much clearer view on what is realistic, because it feeds back into our discussions surrounding the court wanting to give a realistic date for the completion of work to prevent subsequent or further breaches of an order of the court. And I think that's where people can provide evidence and response, and that's often helpful, particularly if you're looking at an N244 application, which made, and actually often you don't have anything at all from the defendant actually filed. And I think that the court would benefit from that if you're saying very clearly that the works cannot be completed until, say, 4 months or even 6 months. If you've got clear evidence to back that up, the court is going to be more likely to be with you. They might make a higher reward for damages as a result, but they'll want to give you a realistic, or not necessarily realistic, because it's this balancing, these balancing factors of obviously ongoing distress to the tenant, where they expected and anticipated the work to be done already.
Yes, I've got Well, two more questions, one of which I can deal with very quickly because it is if a claim settles pre-action for a small claim, for what would be, I imagine it's supposed to say a small claims track case, it then goes on to be resolved by settlement, and then there is enforcement proceedings in relation to that. Would they be able to issue and get the claim onto the fast track, even though it's still, practically speaking, a small claims case? I think that's really what that question was getting at. I think the reason I wanted to answer this question is I think this really goes back to the point that we've been trying to really go on and on about, is that it's not so much about what the value or what the nature of the initial case was. It's about what the value of the breach of contract case would be. So if it has been the case that actually a year has passed since the work should have been completed, meaning that actually the damages for breach of contract would get you into the fast track, or indeed the extent of the work is such that it reaches a value above £1,000, it might be a fast track case at that point. But it really depends on what the situation is since the breach, rather than looking at what the initial agreement was, or sorry, what the initial situation was.
Yeah, for example, if an offer is quite a low offer is made for damages as part of the settlement agreement, for example, £500, it doesn't mean that it wouldn't necessarily, you would get your standard costs. And actually, in my experience, because of the fact that you've been the tenant or the claimant has been forced to make the application, costs are normally assessed on a standard basis.
Okay, we do have some more questions, but unfortunately we are going to have to end there. We've run over a little bit. If you have any other questions that you want answered, then you should hopefully have access to our email addresses, and we're happy to answer them. But we're going to have to end the seminar, and thank you all very, very much for your engagement and all of your questions.
Thank you very much.